Let's talk about the domicile of choice. We said Section 1 of the Domicile Act regulates the domicile of choice, both in respect of who is able to maintain domicile of choice and what requirements need to be met in order to obtain the domicile of choice. So there is two groups of people that qualify for domicile of choice. The first group of people is every person who is over the age of 18 and they have the mental capacity to do so. So I assume that all of us here during this session, we are over the ages of 18 and we do have the mental capacity to choose our domicile of choice. Therefore, we fall into this first group. And the second group is for any person that is under the age of 18. However, that person must have acquired majority status. How does a person under the age of 18 acquire majority status? We spoke about that in family law. A person acquires the majority status when they're below the age of 18 by marriage. So if a person that is under the age of 18 is married, they automatically become a major. The law sees them as an adult. Therefore, they are able to make a choice of where they want to be domiciled. So they can acquire domicile of choice as long as they have the mental capacity to do so. So now, let me take you back. So before this act, before this Domicile Act, the age of majority in South Africa was 21. And when this act came into operation on the 1st of August 1992, the act lowered the age to 18 years old to try and bring domicile closer to the place where a person actually lives, because at the age of 18, many children are said to leave their parental homes to go to work and study. So the only persons who are under the age of 18 and have majority status can therefore acquire domicile of choice, and those who are legally married. So that was before the act. And because emancipation does not give a minority a minor majority status, emancipated minors under the age of 18 years cannot obtain domicile of choice. I will explain briefly what emancipation is. I know some of you already know what emancipation is. I'm going to explain for you so that you do not get confused. We're still going to talk about emancipation later during the module. So emancipation is when a child that is under the age of 18, I don't know, I'm going to explain it proper. So when you have a child and your child is over, let's say they're 16 years old and they decide that they want to work. So we know that in order for a minor to be able to enter into any form of contract, they need parental consent. So when you give them that consent to be able to go and work and enter into some other kinds of contract by themselves, they become emancipated minor. Although they are able to enter into that particular agreement, either it's for work or for an apartment contract where they live, it doesn't necessarily mean that they have acquired majority status like a child who is married. So emancipated minor, they do not have, they cannot acquire the domicile of choice. So another change that was brought by the Domicile Act was the abolition of the so-called principle of unity. So the principle of unity provided that the domicile of a married woman was determined by her husband. So we can see that a lot of there has been a lot of changes in law, like everything previously. Before this act, maybe before even the Marriage Act, everything was in favor of the men. So now the Domicile Act abolished the principle of unity, which is a woman automatically acquired her husband's domicile at marriage and followed his domicile whenever he changed it. even if she didn't live in the new place with him, by providing that there may be no discrimination based on sex or marital state. The Act has changed this position, allowing a married woman to acquire a domicile of choice just like anyone else. So for you to be able to understand how difficult this was for women before the Act, it was that when a woman gets married, or when this couple gets married, the woman, poor woman, will acquire the domicile of their husband. So if let's say the husband was South African, and then they get married in England, and then if the husband was still domiciled in South Africa, the woman will take the domicile of the husband. If let's say now he changes his domicile and now he's domiciled in Britain, and then the woman will take that domicile. And then let's say now the husband moves to New York, maybe he moves by himself, and then he still goes back and forth. And then at that time, his domicile of choice, he has chosen to take this domicile of choice in the United States. And then the poor woman will be now follow the domicile of the husband and also become domiciled in the United States, even if she has never been to that place. But then now the problems that come with that was that when they're divorcing now, remember when they're divorcing, the laws of where the husband is domiciled are the one that is going to apply. So let's say now they got married in England, and then this man is domiciled in South Africa or in the US, and this woman has even never been to the United States or to South Africa. Now they're getting married, and then now he has to go, because she's getting divorced. Now the South African laws need to apply. Now the South African authorities need to get involved in order to be able to dissolve this particular marriage. So this new Domicile Act came into operation, and it abolished that. I think it was a great move. So if section 6 of the Domicile Act, I would suggest that maybe you need to download this Domicile Act and just look at these relevant sections that we're talking about, so that it can actually make sense. You can go through the whole act if you like. I've never gone through the entire act. I just go to the sections and look for whatever that I need. So if you have the Domicile Act and the Divorce Act, and then on the Domicile Act, you read section 6, and then you read section 2 of the Divorce Act, you read them together, it becomes clear that the divorce proceedings, either domicile or residence for a period of at least 1 year before the institution of the action of either party, is sufficient to establish the jurisdiction of a court. So I hope that is clear. And then now let's talk about the requirements of domicile. The requirements of domicile. We have 3 requirements of domicile, namely lawful presence, physical presence, and particular intention. Let me repeat. The 3 requirements for domicile of choice, they are also on the Domicile Act. They are lawful presence, physical presence, and a particular intention. So now let's break it down. The first requirement, that is lawful presence, it simply means that in order, so we're talking about South Africa, in the South African context, in order to acquire domicile of choice, a person's presence in South Africa must be lawful. Therefore, an illegal immigrant may not acquire domicile in South Africa while his or her presence is unlawful. So we leave it there for now. The second requirement is physical presence. So physical presence is required when if you want to comply with domicile of choice, you have to be physically present in the particular place where you want to choose your domicile. You have to be there. So, however, there is no minimum period. You can arrive today, and then as long as you are in South Africa legally, you can arrive today, and then you can decide if you want to be domiciled in South Africa, or if you can have domicile of choice in South Africa. And then the third requirement is intention. So intention is also defined in the Act. It is known as animus manendi under the common law. The intention must be to settle for an indefinite period of time. So if you have the intention to settle in South Africa for an indefinite period of time, then you might be able to qualify for domicile of choice. So these requirements, there are three. They are set out in the Domicile Act. It is lawful presence, it is physical presence, and it is intention to settle for an indefinite period of time. So it's lawful presence, physical presence, and particular intention. So this requirement for intention, so there is a case, it's a case of Elion versus Elion, and then it's very important that you know that this case was decided in 1965, long before the commencement of the Domicile Act. It talks about intention. We can briefly go through the case. So this was the case of of a couple, Mr. and Mrs. Elion. They were teachers. Both of them were from Israel. They came to South Africa to teach Hebrew. And then as they came to South Africa, I don't know how it worked at that time, but they obviously had like a visa or a work permit or whatever it is that they need to be lawfully present in South Africa. So they were given that permission to work and teach in South Africa as teachers of Hebrew. And then they extended their teaching contracts while they're in South Africa. So when they extend their teaching contracts, their work permits are extended. And then they did this a few times until the South African government decided to grant them permanent residence permit in the country. So now they were permanent residents in the country. However, they still maintained their family bonds in Israel, and they still had property. And then they had property, they had family in Israel, and they would still go to Israel from time to time. And then their marriage now broke down to a point where it was entirely broken, it can't be fixed. And then Mr. Elion decided to go back to Israel. So when Mr. Elion decided to go back to Israel, he went there alone, and he left Mrs. Elion in South Africa. And then while Mrs. Elion was left behind in South Africa, Mrs. Elion decided to institute divorce proceedings at the Cape Provincial Division. And the court in Cape Town had to decide whether or not Mr. Elion was domiciled in the area of its jurisdiction at that time, which was Cape Town, where the divorce proceedings were instituted. And the court ruled that he was domiciled in Israel. Therefore, they could not institute the divorce proceedings for Mrs. Elion in Cape Town. They told her, you need to go to your husband, where your husband is domiciled, and that is in Israel, where, because he has left and he has no intention to come back, so you have to go to where your husband is domiciled and institute the divorce proceedings. And Mrs. Elion was heard for, and then she decided to take the matter to the Supreme Court of Appeal. The Supreme Court of Appeal decided the same. They were like, according to this particular case, Mr. Elion is domiciled in Israel. Therefore, they cannot, the High Court in Cape Town doesn't have jurisdiction over this particular matter. So there was a lot of, there was obviously the majority judgment. I'm not going to go into detail with that. And there was also a minority judgment. And then, but later on, the divorce proceedings didn't go on in Cape Town because Mr. Elion was deemed to have been domiciled in Israel. And then there has been another case, apart from the Elion versus Elion case. This one is a more recent court case that happened in the High Court of Namibia, where they had to decide if the person possessed necessary animus mandendi to be domiciled in South Africa in the unreported case. This is the case of Cravato N.O. versus Van Dyk Red. God, I'm not Afrikaans. I don't know how to pronounce this, but it's Redelinghais. So in this case, I'll put that case and then you guys can read it and then you can correct me. Maybe I need to take Afrikaans as a module, like seriously. So in this case, the respondent spent the majority of his time in South Africa, but attended to his farming activities in Namibia in person and constantly. However, he lived within South Africa indefinitely and legally. The court, after this meticulous consideration of the requirements of domicile of choice, decided the following. So I'm going to read the judgment of the court. So they say, when X acquires a domicile of choice in country B, X's intention is to remain indefinitely in country B. Is not excluded just because X leaves country B occasionally and stays in another country D, continually for certain periods. Mr. Barnett submits the respondent was born and he grew up in Namibia, but he moved to the Republic of South Africa when he became an adult. The respondent was factually a resident in the Republic of South Africa for an indefinite period, but not permanently, or intermittently indefinite period, but not permanently. If the respondent had no intention of limiting the period of his residence in South Africa, that is, if he had the intention of residing in South Africa for an indefinite period, I do not see any merit in the argument that the respondent had no intention of residing in South Africa permanently. The animus mandendi requirement of domicile is fulfilled in respect of X, where X has the intention to reside permanently for an unlimited period. So it was judged that Mr. X, this Namibian case, was indeed domiciled in South Africa. Okay, let's talk about the domicile of operation by law. So we still have not much of a long way to go. The domicile of operation by law. So before the commencement of the act, this kind of domicile was called the principle of independence. So the domicile of operation by law is the domicile for people who could not rely on the domicile of choice because they are not free to choose where they want to be domiciled. So there's two categories of people that can obtain domicile of operation by law. The first group is of unmarried children under the age of 18. Section 2.2 of the Act creates a rebuttable presumption that a child's domicile is determined by the parent or the parent with whom he or she normally lives. So children under the age of 18, they usually don't have domicile of choice, but they have domicile of operation by law because that domicile that they have is not of their own choosing. It automatically falls onto them. So once a person turns 18, his or her domicile of operation by law will be retained until the domicile of choice has been acquired. So every person acquires a domicile of operation by law at birth, referred to as domicile of origin. The second group, it consists of people who do not have the mental capacity to choose their own domicile. This group includes mentally disabled and unconscious people, both of whom are domiciled in a place to which they are most closely connected. So once that is out of the way, these two groups, and then we now have problem cases. There is always problems everywhere. So how about the prisoners? Because now these people, they've been arrested and they've been incarcerated. So before the commencement of this Domicile Act, a prisoner had to retain the domicile which he or she had immediate prior to imprisonment. In the case of a life sentence, however, a prisoner would acquire a domicile of choice in the place of detention. But since this Domicile Act came into operation, if the prisoner intends to stay in the place where he or she is serving their sentence indefinitely after the release, and such prisoner will acquire a domicile of choice in the place where the sentence is served. So, I mean, it is on paper, but for me, I see no justice when it comes to prisoners. Obviously, why would you want to choose a domicile of choice for if you are in life imprisonment, like really? But anyway, the other issue for problem cases is people in the military, people like the diplomats, people who are sent to work at certain places by their employers, and at that particular time they cannot choose. So prior to the commencement of the Act, members of foreign armed forces could not acquire domicile of choice in South Africa, as they were not free to choose where they could be stationed. But it was easier for foreign diplomats to acquire domicile of choice in South Africa, even though they were employed by a foreign country who were sent to work in certain places by their employers, and were also not able to obtain domicile of choice because of their lack of freedom to choose. But since this Domicile Act came into operation, these people can now be able to acquire domicile of choice if the requirements of Section 1, subsection 2 are met. And then in this regard, the animus manendi was changed by the Act from settling permanently to settling for an indefinite period, greatly contributed to the clarification of the situation. So you remember that requirement number 3, which said you have to have the intention to settle at that place for an indefinite period. So it works in favor of the people that are deployed by foreign governments to come and work in South Africa. And then let's address the issue of illegal immigrants. So this is the last subject area we're going to talk about before we close for the day, the illegal immigrants. So both in terms of the common law and the new Domicile Act, which was came into operation on the 1st of August 1992, we say there needs to be a lawful presence. So they have to be here lawfully. So illegal immigrants can therefore not acquire domicile of choice in South Africa at any cost. As long as that person is illegal in South Africa, they cannot acquire domicile of choice. Unless if that illegal immigrant can obtain permission from the government to remain here, then we can give them a domicile of choice. If let's say if somebody has we have a person that has been living in South Africa for legally for a couple of years, let's say 5 years, 6 years, 10 years, anyone, they've been living in South Africa for that period of time, and then something happens and then they get deported, so their domicile of choice will be automatically terminated because their residence in South Africa has become illegal. So this brings us to the end of this session. We have 10 minutes left before this cuts us off. Does anyone have a question? Oh, I see all of you guys are still here. Does anyone has a question before we close? Dumi, do you have a question? Ask me a question, Dumi, I insist. Come on, just one question from you today. I would assume that you perfectly understand everything because I have never received a question from you.
No, not really perfectly understand everything.
Yeah.
But where I'm lost, I'm just thinking that I should also go and check for myself.
Okay. No,
Find out all of
I
myself.
perfectly understand. So if you happen to have any questions, you have my WhatsApp number. You can send through those questions, or you can send me an email, and then we can take it from there.
All right.
Yeah, sure, to me. Mark.
All right. Thank you very much.
Okay, to me.
Hi,
Mark.
Mr. T.
Yes, Mark. Do you have
Yes,
any questions?
yes. I was just thinking about the prisoners. I mean, by law, they were convicted on whatever they've done. And I mean, they haven't got actually a choice.
Yeah,
I know
definitely.
you mentioned about the prisoners and it's unfair. But I mean, with this new act, how, I mean, just to clarify, I mean, to get clarity on this thing, how can a person that has been in or got a sentence have a choice? Because I mean, if you play with the words, he doesn't actually have a choice. The state send him to a certain.
Definitely, that's where my point is, that like this person has been imprisoned for life imprisonment, and they definitely have a choice. If they're obviously not going to come out, why do they need to have the domicile of choice? Because it serves them no justice, unless if they obviously know that they're going to come out, and then it's going to be beneficial to them. But nonetheless, for me personally, it just doesn't make sense for me. But anyway.
Yeah, I'm 100% with you. I'm struggling to get hold of it.
Yeah. Okay.
Yeah, I'm struggling. Even if that's a temporary
Yes.
period of time that you're gonna spend there, say
Yeah.
for 5 years, it's still gonna be what, because what you have said in the commencement of this thing is that no person shall be without a domicile.
Yeah.
So if your domicile is in Portsmouth, for instance, for 5 years, that's where you're gonna be remain for that
Yeah.
5 years.
Yeah.
But my next question to you is, what about homeless people?
So with regards to homeless people, it's the same. Remember, I spoke about persons without mental capacity.
Yes.
Yeah, so the persons that don't have that are mentally incapacitated, their domicile is where they are closely connected to. So that also counts for homeless people. So let's say, for example, before this person became homeless, they were domiciled in Johannesburg at a certain address where maybe because they most of those people will have they will have families and things like that. So where they are all closely connected to, that is where they are domiciled for the purposes of law.
Okay, so you want to tell me the homeless people all fall under mentally ill?
No.
Persons.
Please don't get me wrong. That was an example. That was an example that, like, for example, the mentally incapacitated people who are not able to choose at that time, their domicile is regarded as to where they are closely connected to. So they look at the close connections of that person, because at that time, that person, the homeless people, they actually don't have a choice. But we look at where are they closely connected to? What was their last domicile? And what is the position at that particular time?
Okay, now that's fully understood.
Yeah. So yeah, that's it. And Nhlanhla, do you have any question? Any question, Nhlanhla? Okay, I would assume Nhlanhla doesn't have.
No, I don't have. Sorry, I don't have any question at the moment. Everything's clear.
Okay, no problem, Nhlanhla. If you guys have any questions, you are more than welcome to send me a WhatsApp privately. You can also send me an email, or I'll put my email address here next time, and then we can always have that conversation. I was thinking that okay, let me just stop this recording. So our session will end here today. Let me stop the recording quickly, and thank you very much. The recording